Judgment in the matter of Vedanta Resources PLC and another versus Lungowe and others.
Lord Briggs will explain the decision of the court.
The Nchanga copper mine is one of the largest in the world. It is situated in Zambia. Some 1,800 very poor Zambian people living and working near the mine complain that their livestock, their farms and their drinking water have been polluted and their health and well-being ruined by poisonous emissions from the mine into local waterways over many years. They wish to seek compensation from those they regard as responsible, namely the owner of the mine, KCM, which is a Zambian company, and its parent company, Vedanta, which is incorporated in the UK. They have got together and brought what is called a group action against both companies in the English courts, rather than in the local Zambian courts. Both KCM and Vedanta say that the claims should be brought in Zambia, and Vedanta has, for that purpose, offered to submit to the Zambian court's jurisdiction, so that both defendants can be sued there in a single action. Everyone agrees that the claims are all subject to Zambian law, including legislation regulating mining in that country. All the claimants live there. The alleged emissions and pollution all occurred there. Most of the relevant company personnel and documents are located there. The Zambian courts are able to understand the local dialect used by many of the claimants, as well as English. Most reasonable observers would think that Zambia was the natural and most appropriate place for the litigation to be conducted. But the claimants say that England, not Zambia, is the proper place for the proceedings as a whole. They say they have a right to sue Vedanta in England as Vedanta's place of domicile under Article 4 of the European Union's Brussels regulation. They have no such right against KCM, but they say that the claim against KCM should therefore also be allowed to be pursued here, so that all the claims against both defendants can be dealt with in a single court, rather than in two courts, one here and one in Zambia. But they also say that they cannot obtain access to justice in Zambia. This is not because there is anything wrong with the Zambian judges, the Zambian courts, or the Zambian procedure for large group actions. On the contrary, it is clear that the independent Zambian judiciary, the courts and the civil procedure would ensure a just trial of a large environmental group claim like this one, if it could be mounted. The lack of access to justice is, they say, because they cannot fund the claims in Zambia, because they could not obtain legal aid, because Zambian law does not permit what are called conditional fee agreements, whereas English law does, and because there are no law firms in Zambia which have the resources and experience needed for this very large and complex litigation, whereas those are available in England. In response, the defendants say, first, that it is an abuse of EU law for the claimants to use a claim against Vedanta, which they say has no real prospect of success, as a peg on which to hang a claim in England against the real defendant, KCM. Secondly, they say that access to justice is available in Zambia for claims like these, as they say is demonstrated by the success of similar group claims there in the recent past. The defendants therefore applied to stay the claim against Vedanta and to have set aside the service of the claim out of the jurisdiction upon KCM. The judge, Mr. Justice Coulson, agreed with the claimants. He found that they genuinely wished to obtain damages against Vedanta, not merely against KCM, and that their claim that Vedanta had incurred liability for negligence by intervening in the operation of the mine by KCM had a real prospect of success. Although the opportunity to sue KCM as well in England by using Vedanta as an anchor defendant was an important part of their motivation for suing Vedanta here, it was not their sole motive and not therefore an abuse of EU law. Since they had a right to sue Vedanta here, the only way in which the claim against both defendants could be determined in a single set of proceedings was if the court permitted that to happen. So England was the proper place for the trial of the action as a whole, however strong the links with Zambia. Finally, and after an extensive consideration of the evidence, including facts about the outcome of recent similar claims in Zambia, the judge concluded that the claimants could not obtain access to justice in Zambia for the funding and resource reasons to which I have referred. The Court of Appeal agreed with the judge's analysis. With one important exception, this court unanimously agrees with the courts below. The judge's conclusion that the claimants genuinely wished to obtain damages from Vedanta was a finding of fact confirmed by the Court of Appeal, with which it would be inappropriate for this court to interfere. There was therefore no abuse of EU law in suing Vedanta in England. The judge was entitled to conclude on the available evidence that the claim that Vedanta had taken a sufficient part in the running of the mine, or assumed a sufficient responsibility for doing so, although not straightforward, was sufficient to require determination at a trial. Critically, the judge's conclusion that the claimants could not obtain access to justice in Zambia because of the funding difficulties already described, and because of the non-availability of a law firm with sufficient resources and experience, was also a finding of fact, again confirmed by the Court of Appeal, for which there was a sufficient evidential basis. It would therefore be wrong for this court, and contrary to its settled practice, to interfere with it. This meant that the claim against both defendants ought to proceed in England, and that the appeal should be dismissed. The point of principle upon which this court disagrees with the courts below is this. They concluded that where, as here, a claimant has a right to sue one of two defendants in England, because that defendant is domiciled here under the mandatory provision in Article 4 of the Brussels Regulation, then England will usually be the proper place in which to bring a closely related claim against the other defendant domiciled outside the EU. This is to avoid the risk of conflicting judgments about the same matters, irrespective of the strength of the connecting factors between the claims and the place where that other defendant is domiciled, in this case, Zambia. Avoiding the risk of conflicting judgments is certainly an important factor when the court is asked to permit service of an English proceedings on a defendant domiciled outside the EU. But it is not a trump card. Following earlier authority in the commercial court, the judge thought that it was a trump card because the claimants would otherwise be deprived of their right under EU law to sue the English domiciled defendant in England. But that EU right still exposes the claimant to having to make a choice, even if all the defendants are domiciled in different EU member states, so that the jurisdiction question is entirely governed by EU law. The claimant can either exercise its Article 4 right to sue each defendant in the member state where it is domiciled, taking the risk of irreconcilable judgments, or it can avoid that risk by suing all of them in the place of domicile of one of them, under Article 8. In the present case, although KCM is domiciled outside the EU, the claimants have the same choice, either to take the risk of irreconcilable judgments by insisting on suing Vedanta here, or to avoid that risk by suing both Vedanta and KCM in Zambia. This is because Vedanta has agreed to submit to the jurisdiction of the Zambian courts if sued there. It is the claimants who are mainly affected by the risk of irreconcilable judgments. In such a case, if all the connecting factors otherwise point to Zambia as the proper place for the claim, then they may outweigh what the judge wrongly regarded as a trump card in favour of English jurisdiction. The judge was in no doubt that for the reasons already explained, all the factors connecting this claim to a particular country favour Zambia, and this court agrees with that assessment. Had it not been for the access to justice problem, this court would therefore have refused the claimant's permission to serve these English proceedings out of the jurisdiction upon KCM in Zambia, leaving it to the claimants to choose whether to avoid the risk of conflicting judgments by suing Vedanta there as well. As it is, however, the non-availability of access to justice in Zambia means that the proceedings against both defendants must continue in England. The court also takes the opportunity in its judgment to remind the parties and other court users of the need for proportionality and economy in the litigation of issues about jurisdiction.
The court will now adjourn.